Hey, good Saturday afternoon. Carl Rominger here, 540-0580. If you have a legal question, legal concern, you want to sound off about something, if you're not at the 828 rally right now, or maybe if you're there listening on your iHeartRadio, call 540-0580. I'll answer your legal question here on the air. Well, it's been a busy week. Let's see. Vinny Manfredo in my office had a self-defense trial up in Perry County. He did a good job. He beat murder 3 and voluntary homicide. It involved a guy who shot somebody with a BB gun in self-defense. And the jury convicted of some charges but acquitted of all the major ones. So we're very happy about that and very proud of Vinny. He worked very hard on the case. I know all the hours he put in because I like to haunt the office at strange hours, and I would come in the evenings or on the weekends, and I would see him in there working on his trial. And, you know, a lot of times when I quote somebody a trial fee and they say, well, oh my gosh, I can't believe that a 2-day trial is that expensive. I always tell people, you figure that a lawyer does about 3 days of preparation for every day they plan to be in court as just a rule of thumb. Could be more, could be less. But keep that in the back of your head that a trial is a very, very difficult event. It requires a lot of preparation. And you have to know, now think about this. You got to know who the witnesses are going to be, what kind of evidentiary issues are going to come up, what's the particular law that applies to the particular charges, what are the facts you have to prove or disprove, what witnesses are going to prove or disprove those things. And then, of course, there's all the other things that go into trial, too, besides those tangible portions. So anyhow, 540-0580, 540-0580. Call in. I'll answer your legal questions here on the air. Selma, you're on WHP with Carl Rominger.
Good afternoon, Carl. My question is, when you belong to a community association, you pay dues. Is there any law that says they must give you a treasurer's report, say on a yearly basis or at any time?
The short answer is yes. I think there is some requirements on homeowners associations and how they're managed. I know that there's the Condominium Act. And I'm just trying to think if there's a corollary. But the short answer is you should have bylaws. Mm-hmm. Have you looked at those?
I didn't look this particular thing up, no. But I do have recent ones, yes.
Usually the bylaws are going to contain, what the plans of the organization are in terms of how often you're going to report out the accounts, et cetera. And have you tried going to one of the meetings? Yes. And when you ask the status, what did they say?
Well, they want to know why you want them, and they just hem-haw around. It's not an easy thing to get.
Now, the other little question I have for you, do they employ a professional management company, or do they just do it themselves?
Yes, they do. They have a professional management company, and they will not give it to me.
That should be no problem to get. I mean, let me put it this way. I'm not sure if you're entitled to every line item, at least in the first blush. But you're certainly entitled to an overall accounting and an annual statement.
Well, they give us their budget. They have no problem with that.
Right.
But they actually where the money is going and what it's going for, we just don't know. I mean, there's nothing in writing as to say. Yeah.
Now, how many people are in your association?
Oh, like 170.
Okay. Well, what you got to do is find some other concerned citizens and get them to the meetings. You get enough people there, and you can usually topple the administration with surprisingly few votes.
Okay, well, I thank you. I just wondered if there was an easy way with.
There's no easy way to do it. If they're not going to provide what they're supposed to provide for you, you still have to go to court to produce it. Or you might want to have a guy like me write a letter to them on your behalf and say, "Hey, we want to review the books."
Okay. And it's not that you want to review them. I mean, there should be they should be reviewed at the end of the year. Shouldn't there be?
Should be an audit.
An audit.
Time for an audit.
Yeah. I don't know if they have it audited or not.
Yeah, time for an audit. That's what I think. I would get people together and say, "Hey, listen, you know what? I'm not gonna be a jerk. I'm not gonna try to micromanage everything." And I realize I got to go through the association, but what I want is an auditing report. I want us to, maybe if it's every year or whatever, we hire an auditor just to come in and say, "Okay, everything is like everybody thought it was."
Okay, thank you very much.
All right, Selma.
Bye.
540-0580, 540-0580. Remember, if you buy property and it comes subject to a homeowners association, you might have to get involved if you really want to find out what's going on. Tom, you're on WHP 580 with Carl Rominger.
Yeah, Carl, thank you for taking my call. I got a question for you. This is a reference to propane that was stored on my property. I bought a home 1 year ago.
Okay.
And according to my property agreement, my sale agreement, it says that all fuels that are stored on my property are considered my property. But unfortunately, after a year, I had my propane tank removed, and I never set up an account with the gas company at all. They went ahead and sent my fuel, whatever the remaining balance was, to the previous owners who sold the home to me a year ago. Now, you haven't heard the rest of this. Now, what happened is I called up the gas company this propane company, and I asked them, I said, well, how come I didn't get my check? They told me, well, we sent it to the previous owner. I called up my real estate agent up, and they told me that your propane acts like as a utility service. I said, well, wait a minute. On my sales agreement, it says all my fuel that is stored on my property, that's cooking fuel and heating fuel, is mine. They told me that propane fuel is not considered fuel at all, and that it belonged to the previous owner. Could that be correct?
I mean, the short answer is you had a sales agreement, right?
I got the sales agreement, and it says that all cooking and heating fuel that is permanently stored on the dwelling, on the property, is mine.
Right.
Now, they told me that the storage tank belonged to the gas company, the propane gas company.
Right, so they're saying it wasn't permanently stored on the property?
Well, yes. Well, the tank was rented out. But you know what? I never set up an account with the propane company at all. They just went ahead and...
Right, so they rented a tank, but they had bought the propane, presumably.
Yeah.
But the next question is, did they buy the propane ahead of time, or did they just...
They brought the propane ahead of time. I bought the house.
Yeah.
The propane sat there for a year. I never used it. The tank, I never paid any rent on that tank. But the thing is that when that tank was brought back to the other company, I told them, I said, just send me the check for the fuel that was stored in that tank. I'm going to do business with somebody else.
Right.
Is that considered like a utility, rated utility, or...
You know, the short answer is I got no idea. The long answer is it sure seems like you intended with the previous seller to get the benefit of that fuel.
Uh-huh.
So vis-a-vis them, I think you would have a breach of contract that you could bring, because you could say our definition, we don't care what the propane company thinks about it. We care what any third party thinks about it. Your understanding with them is that you were getting that. And when the refund came in, they should have forwarded that to you.
Well, here's the thing. I think they failed to set up an account for me there, but I told them, I said, look, I don't want to do business with you. What I think they should have done is set up an account, establish the account there. Then they should have sent me the check for the fuel that I had turned in to them. Because according to my sales agreement, it says that all fuels, that includes my heating fuel.
Yeah.
Right? But, you know, the real estate people told me, this as well, they can't take your heating fuel, but they can take your propane fuel. I said, okay, that's fine. But I should have been reimbursed for that. Would you say I need to go to the magistrate and go to small claims court?
Yeah, I think you could absolutely try that. I mean, let me put it to you this way. Am I 100% sure that you have a claim? No. Am I 80% sure? Yeah.
I got it in writing, and here's the thing. Here's the ticker. The previous owners told me that they did not own the tank.
Right.
Okay, I understand that.
Right, but the fuel's different.
On my sales agreement, it never said anything about propane at all. It just says cooking and heating fuels.
Is the propane used for cooking on the premises, or was used for cooking?
I used that for the stove.
Well, there you go. It would seem to me that was the intent of the parties at the time, and I think that would control in the plain language of the agreement.
So you're saying that I have a good, legitimate case?
I think you have a very legitimate claim. Am I certifying it 100% winner? No. Am I saying that it's well worth pursuing a small claims court? Yes. Why am I not certifying 100% winner? Because we lawyers are a nervous lot. All right, Tom, I got to go to break.
Okay, thanks a lot, Carl.
All right, no problem. 540-0580. See you after the break. Hey, welcome back. Carl Rominger here, 540-0580. Show's Weekend Appointment, where I answer your legal questions. And, of course, remember, if you're out riding around, you can't call in right now. We're going to be live on the air until 3 p.m., and then from 3 till about 3:45, you can keep calling in, and we do the bonus podcast hour so that you can still get your questions answered, and the show gets broadcast on the ticket tomorrow morning, and it gets put up on the web where you can listen to it. And, of course, if you're not a caller, you can go to Facebook and find it under my profile. You can go to weekendappointment.com and find it, or you can go to WHP580.com and listen to it a few hours after we do it. So don't forget 540-0580, and you keep calling past 3 o'clock. And who's next here? Jeff, you're on WHP 580.
Hello.
Hey, Jeff.
Yeah, I have a question involving potentially malpractice.
Okay.
And it's pretty simple, I think, but I went to an emergency room because I was experiencing some problems. They did a whole battery of tests, didn't find anything, and said, you can stay here or go home.
Okay.
And I essentially decided, okay, I went home and checked checked the internet and put my symptoms in and said, boy, that's exactly what I have. And I went to the same emergency room the next morning, and said, I think I have XYZ, and I would like a prescription for this medicine, which is basically an antibiotic. And they said, well, we can't test for that here. You have to go see your family physician.
Mm-hmm.
So all the tests they did the previous day, if I had told them I thought I had that, they're telling me I can't do that, or something to that effect. And essentially, when I finally saw my family physician, went to see he sent me back to the same hospital to have the test done there that they refused to do. Does that make sense? And basically delayed the treatment for about 2 weeks.
Okay, and as a result of the delay of treatment, how were you harmed?
I'm not sure. Okay, I'm not perfect yet.
Okay.
Okay, and it could have delayed and stuff.
And that's an essential element of a malpractice case or any negligence case. Not only do you have to have negligence, and not only do you have to have causation of the negligence to the harm, but you have to have the harm, and you have to be able to quantify the harm in a medical case to a reasonable degree of medical certainty.
Right. Well, I mean, I went and told them I believe I have XYZ problem.
No, I understand, but I guess what I'm trying to tell you is that if a year from now, let me give you an example. Let's say the doctor misdiagnoses your cancer, and you have a particular kind of cancer that's 100% fatal.
Right.
The fact that he misdiagnosed it and thought it was a different fatal cancer, that's negligence, but it probably didn't change the outcome.
Right.
On the other hand, if he misdiagnoses you with a fatal cancer and you actually have a very treatable cancer, but you decide to go off and do your bucket list and fade away, your family probably has a really good claim.
Right.
So we're only half baked right now. We're not sure if this souffle is going to rise or not.
And to my knowledge, this is not a fatal type problem.
Right.
It could be long term, could be difficult. But the biggest question I have is, right now I'm getting the bills from the emergency room for my copay for this, because I do have insurance. I'm wondering if I should write a letter with the payment and say, here's what you did by cashing this check. You acknowledge you did this and refuse to treat me.
Right. You obviously could absolutely do that. Or you could refuse to pay for services that weren't adequate.
Right. I mean, the first day they did a whole bunch of tests, and if they had done these other 2 tests at the same time, that would have been 2 more tests, right? So I'm not saying they didn't do the tests. I'm just saying I requested basically other things, and they said we can't do those, even though they're commonly done at that hospital, and they were eventually done.
And I don't know, because I'm not the doctor, so the first thing I would want to do is find out from a licensed professional what their opinion of the situation is. You and I can speculate all day long, But the law does say in order to bring a malpractice-style claim or in order to prove that, you've got to show that a licensed professional would find negligence or malfeasance.
I don't know if it's, my question is just about the simple payment of their services.
Well, I understand that, and that's what I'm saying is I don't know. I don't know. I mean, maybe a doctor's going to come in and say, based on the circumstances, patients can come in and ask for 1,000 different tests, but this is all I would do under the protocol. And a different doctor might do something different, but I think they were objectively reasonable under a standard of medical care, and therefore he got what he asked for.
Right. I'm not saying the first day. I'm saying when I came in and said, I think I have this.
Right.
And they said, we're not going to test you for that. We're not going. They just sent me home.
Yeah. No, I understand that. And that's what I'm trying to ask is whether or not that's reasonable or not. I don't know. All right, Jeff, I got to go.
All right, thanks.
540-0580. I'm not a doctor. I don't know, Jeff. I mean, the answer is 540-0580 is the talk line number. But, what am I supposed to tell him? The answer is maybe it was wrong, maybe it wasn't. I mean, if a guy comes to my office and consults with me and I tell him there's nothing that can be done, and later on some other lawyer thinks there is something that can be done, but two lawyers could reasonably disagree on that course of action, and both would be considered to have given good advice in terms of professional standard, because one guy's, saying, well, this usually would never work, but maybe it might, and the other guy's saying nothing usually works, so why waste your money? We might be able to have two different sets of advice that are both found to be adequate or professional under the circumstances. Adam, you're on WHP 580 with Carl Rominger.
Good afternoon. Thank you for taking my call. I have a question concerning landlord-tenant law.
Okay.
I have an individual I rented an apartment to in Altoona, Pennsylvania. I own some buildings down there. Met with him in February. I actually gave him the last 10 days of February, no charge for rent, because I met him the end of January, starting the lease February 1st. With a verbal agreement that he would pay for the utilities for the last third of the month. Since that time, this individual's rent has been significantly late every month. Mm-hmm. He still has not paid for those utilities for the end of February. And at the end of June, around the 20th, I sent him a certified letter and a regular letter basically stating that if he did not become current in both his rent and the utilities by July 1st, I would proceed with an eviction.
Okay.
He never signed for the certified copy of the letter. However, the one that went standard mail, I never got back. So I have to work under the assumption he at least received that.
Although I can tell you that in the law, we usually say that if the certified mail comes back unclaimed,
yes,
then we don't presume, for instance, that he got the first-class mail. If it came back refused, then we know he's getting his first-class mail.
Oh, all right. I did not know that.
But you can do a notice to quit, and a notice to quit can be simply taped to the door as well.
Okay. Honestly, this is where the situation is going to get a little diluted. My father was down at that particular property on July 13th for some maintenance in another apartment. He saw this individual in the building and questioned him about his rent.
Mm-hmm.
And after some conversation back and forth, he wrote my check a check to my father dated for July 20th on the 13th for $720. This is still about $300 short of what he owed at that point. He apparently received notification that we had filed with the magistrate to evict approximately 2-3 days later. He sent us an email because he apparently doesn't have a phone or won't answer the phone, that he was stopping payment on the check and made some pretty outlandish accusations.
Mm-hmm.
At that point, the way I looked at it is I had a check for $720 in hand. So I replied back to his email saying, look, I will wait until Monday to deposit this check, the 23rd, I believe it was. If the check clears, I will not proceed with the eviction. If it does not clear, I will proceed with the eviction.
Mm-hmm.
Since that time, the check, obviously, he had stopped payment on. I found that out about middle of this past week. but I also received...
Shoot faster because I want to run into my half-hour break here.
The other piece is I received notification this week as he has filed a counterclaim for $720 against me for lost wages, cost of moving, and for $30 for a stop payment on the check.
You should. Those are bogus claims, and he didn't. That courts are not going to award those in most instances. Lost wages work from a landlord-tenant dispute makes no sense.
Okay.
So I think you have very little to worry about.
Okay.
Does that make sense?
Mm-hmm. I was wondering it's on the 14th, should I get counsel, or is this something I've handled these cases on my own in the past?
I think you're fine if you just explain to the judge basically what you explained to me, show your documentation, bring your father along to make sure that the judge knows that he was aware of what, that conversation that took place.
Okay.
And you'll be fine. If you're not, the good news is you have a 30-day right of appeal automatically. Then you can get counsel involved.
Oh, great. Thank you.
No problem.
Good deal.
All right, dude.
Thanks.
540-0580. Carl Rominger here answering your legal questions. I'll see you after the break. Hey, welcome back. Carl Rominger here answering your legal questions. WHP 580. 540-0580. Friend of the show, Mark Virgenis, called me earlier today and said, did I see the Pennsylvania Academy of Music suing donors? And that's been down in the news. I'm not sure if it's made it up in the news up here in the North Country, but at least down in Lancaster, it made the newspaper that they've threatened to sue a donor for a pledge. And, of course, this is one of these deals where you donate money to charity, and it always leaves open the question, is a charity, a pledge to a charity, something that can be collected? And interestingly, one of the cases, and I remember this from law school, but I looked it up just to make sure, popped it up here during the break, Allegheny College versus National Chautauqua County Bank from 1927. Well, Allegheny College in Meadville, Pennsylvania is my alma mater for undergraduate. And I always remembered that when we were in law school, the Allegheny College case was the one we read. And there's a great quote in there. Cardozo wrote it. And I put the quote up on my Facebook page. I'm not going to belabor everybody with the point, but if you go check me out on Facebook, you can read the quote from the case, because I think it's a pretty salient of all the legal decisions that we read these days. Sammy, you're on with Carl Rominger. What's going on?
Yeah, Mr. Rominger, first I want to compliment you on the way you defend due process in America.
Thank you.
It's a lot of Americans don't really appreciate the due process. But the only thing is now, I wish the courts were a little more open and you didn't have that fear of cameras.
I wish they didn't either, and trust me, although I would probably have to make sure I primped and prompt a little bit better, and of course, all that oily sweat probably wouldn't look so good either, because on real TV they get to I say real TV and like the news and everything, they get all made up and do themselves in a way that makes them look a little bit more presentable. In real life, we tend not to look so good on camera.
So we could overcome that easily by this system which I was talking to you about. And by the way, it's going to be a one-page thing, and I think I got it all figured out. You'll be the judge, okay, and the audience will be the jurors, and let's see, we can put the defendant or the other parties involved.
You're not making me the judge, are you?
We're going to make you the judge.
On
radio. You'll be on radio.
Never call a lawyer.
This will be the People's Court on radio.
Never call a lawyer judge. What happens is we just sit on our butt and wag our tail after that. So,
well, I don't know, whatever. Anyway, so this thing is real simple now, and in fact, we could call it either the People's Court or the Naked Court. What is your preference?
I think we'll go with the People's Court, but that might already be owned. We might have to license that trademark, Sammy.
Okay. Now, by the way, so here's the business plan. There it is. I mean, what else do we need for the business plan? Huh?
Well, I understand, and of course, reality TV does seem to be a hit these days.
Yes, it's a big hit. Well, your program's a big hit also.
Well, you know what? It's a pretty simple program. All I do is put a little of my time in every weekend here and answer people's legal questions on the air. And Sammy, I appreciate your comments on due process. I got a couple callers holding, so I'm going to take them. But if I ever steal your idea, feel free to sue me.
No, I'm not going to sue anybody. That's free. That's one of my free ideas. I'm a $1 a year man now.
All right, my friend. Take care.
Bye-bye.
Patrick, you're on WHP 580 with Carl Rominger.
Hello, Carl?
Yeah, how are you?
Yeah, good. How are you? Thanks for having me.
No problem.
I guess my question today is about community property. I'm a guarantor on a corporate loan for a corporation that I worked for and left back in 2005. And, over the last couple of years, tried to get the rest of the shareholder population to take over my shares. And now the company's fallen on some hard times, and they're behind on one of the loans with one of the big banks around.
Okay.
And I'm wondering, what do I need to do to protect myself as far as, community property? Can they come after, like, my house that's in my wife's name with me, or bank accounts that I'm in with other siblings and parents with?
What's your relationship to the company?
It's a subchapter S Corp, and I hold 50% of the shares.
Okay, you hold shares.
I'm a shareholder, but when we were signing the mortgage and the line of credit, the only way the bank would give the credit line out was to have the officers personally guarantee the line in the mortgage.
Which is a famous thing that happens. It makes sense. They go, well, great, you created a brand new corporation, but we don't know its creditworthiness, so what we want is to get personal guarantees from the officers. And the answer is, to the extent that that personal guarantee affects you, they absolutely can reach you. To the extent that any property owned by you is titled appropriately by you and your wife, meaning if your deed says, for instance, joint tenants in the entirety, then they can't reach that property. If your deed says tenants in common or tenants with right of survivorship, it's potentially that they could.
I see.
But as a husband and wife, hopefully somebody helped you do your deed the right way.
Right. Okay.
Which, by the way, just side note, all those people out there who don't want to see the lawyer about getting their deed done, I'm not gonna. A lot of realtors know how to do it, but a lot of times, if you don't have a lawyer review it, you might not have the exact language you want to protect the marriage or the marital property in the deed, and that's one of the reasons I always have a lawyer involved in a real estate transaction.
And in the event of a bank account or a stock account that is set up joint tenant with the right of survivorship, and I'm one of the additional names listed on with my mom and my sister, what is the exposure there?
Because it's not marital property, the exposure could be your interest in it. And when somebody attacks your interest in it, we then treat it as tenants in common when we sever it. So when you have joint tenants with right of survivorship, and so let's say you and I had an account together, even though we'd each own the whole thing, because there's two of us, presumptively it would be 50-50. And so if they severed the interest, they could get up to the 50% interest would be yours. So if there's three people, up to a third, which would be your interest.
And what process would take place before that happens?
You'd have to be sued, they'd have to get a judgment, and they'd have to execute. And if you really want to delay something like that, you could delay it for a very long time.
Long enough to have a name removed from it, or?
Well, we got a statute out there that says that if you fool around with that stuff and the other side discovers at the time you knew or should have known you had a potential claim against you, then we can set those transactions aside as fraudulent.
Right, but they could technically only go after that interest in the amount of any arrearage.
Right.
Okay. I'm just looking at a worst-case scenario should the other corporate shareholder decide to file bankruptcy and walk and leave me holding the bag here for everything.
Right, which is your other dilemma, which is anytime you're in a joint debt situation, if the other side goes bankrupt, you get left holding the bag. Absolutely.
Right. So it's almost worth looking at maybe absorbing all of the shares and then setting things right, because I'm sure there's at least enough equity in the building and all the corporate assets to take out any liabilities. But with the big bank, even though they were supposed to help Main Street business, when we asked the big bank for a life preserver, instead they threw us an anvil.
Yeah.
And that's all I could say about that.
Yeah, and that doesn't surprise me. Listen, one of my friends used to say, a guy I went to law school with, named Glenn. He always used to say, it's the banks. It's the banks that destroy the economy, because whenever things start to go south, they're the ones who call in all the capital, and they're the ones who shrink the economy. And what they do is, and you know this, I mean, a lot of people don't realize this, your mortgage usually doesn't have a balloon in it, but most business loans, somewhere in there, have a call option where the bank can say, well, we're not comfortable anymore. We're calling in the loan.
Right.
And now, realistically, most small businesses can't survive a loan call-in. More importantly, if you call in the loan on one small business and they fold, now they were the customer of 5 other small businesses, and they have to fold. And so pretty soon it's like a self-fulfilling prophecy.
It is.
And so throughout the history, if you study, you'll see that these loan calls and these banks who then stop loaning money, but more importantly start sucking as much money as they can out of the economy and back into their coffers, are the ones who can usually deflate the business community faster than anything.
And that's correct. And had they not reduced our line of credit for no reason after we were on time with payments for nearly 13 years, we would not have to have laid off staff and eventually ourselves and, taken our business out. I believe they helped to destroy jobs when they were being encouraged by the White House to help create them.
Well, and the answer is, the reality is the White House, I could go on and on about the White House, but the reality is no White House, nobody has ever been able to get the banks to do what is rational overall. In other words, if you really thought it out, at a certain point you would say, well, if all you guys do the same thing, if only one bank did this capital call, well, they'd be geniuses. But if everybody does it, you all go down together.
Mm-hmm.
And that's the problem. It's the tragedy of the commons, which is the old adage about the farmers who would take their sheep down to the commons to graze. And no farmer's sheep, particular small flock of sheep, was responsible for overgrazing the commons. But every farmer had too many sheep collectively, and therefore the commons were overgrazed, and then the commons were destroyed, and there was no grass for the sheep to eat, and then the farmer didn't have anywhere for a sheep to graze.
Good analogy.
And it was called the tragedy of the commons. And so each farmer's rational choice was he couldn't get rid of 4 or 5 sheep because he couldn't afford to in any given year to save the commons. So everybody did something individually that collectively destroyed their ability to make money individually or to survive. And that's exactly what the banks do. I got to go to break, but
okay, thank you so much for your advice.
If you need anything else, you know where to find me. Go to weekendappointment.com, all right?
Okay, thank you.
All right, thank you. 540-0580. Carl Rominger here. I'll see you after the break. Five 540-0580. Oh man, that's a good song though, Shane. Don't you know? I can't drive 55, and I try not to speed. I really do. But it seems like what we need to do is raise the speed. Here it comes. We need to raise the speed limits again. That's my plan. It's nice when you go someplace where they have slightly faster speed limits. And I know there's some people out there, oh, it's unsafe, it's unsafe, it's unsafe. Well, let me give you a little hint, all right? The left lane, it's the law of Pennsylvania. It's the law of Pennsylvania. You have to get in the right lane and yield to the traffic in the left lane. So quit riding along in the left lane and complaining about how fast people are going because there's somebody on your tail. You have the duty to yield if you're in the left lane. If there's somebody behind you and you're in the left lane, get out of the left lane. 540-0580. Richard. What's going on, Richard?
Just let me get off the speaker. Okay. Carl, my wife was in an accident in a Holland America trip to Alaska.
Okay.
Riding a raft. It was supposed to be in the easiest of all the rapids in Denali, which is the first part was the land trip. The raft hit White Rapids. The 3 women who were up front, including my wife, went right over on their backs into the bottom of the boat, hitting their heads on an aluminum bar that was there. We got just some minor treatment at a clinic in the area. and it was interesting. The supervisor advised the three women against going there because of the cost that during the night. He said to wait till the next day. My wife went up right that night and got a lot of painkillers and had whiplash. And the physician there said possible break. We couldn't get an X-ray till we got back into Anchorage 2 days later. We had to go out, grab our own cab, and get to the hospital, to the ER. She came back to see her doctor now, and just basically, these are touch points. And the doctor says she is severely tight. There doesn't seem to be any break, but she wants her to go into physical therapy because the whole top of her back is just all tightened up. I'm just wondering, is there any cause of action here? The agreement, we signed a waiver,
right?
But the agreement says all proper safety equipment is being provided. They wore no helmets, and there was no padding on this bar across the bottom of the raft. Do you see any possible action there? My wife, from that point on, was in bed by 8 o'clock every night. This was our 25th anniversary cruise. But she was in every. We went onto the ship right from Anchorage, and she just basically couldn't participate in any of the entertainment. Though she did go out during the day on some some places where she didn't have to make food. Now she was given a neck brace at first by the clinic. And used that for a while.
Well, it reminds me, I was skiing one time out west, and I had a little accident, hit my back up pretty good. And I remember when I went to the clinic, one of the things the doc said to me was, well, you're going to ask the question? You're going to ask the question? And I was like, what question? He's like, well, can I still ski? And I was like, well, no, I wasn't going to. He's like, well, you can't. I said, well, good. Today was my last day. So, when you get injured on vacation, you always hope that it obviously is not going to be during the heart of it. Now, the next thing is, if you didn't have a trip insurance or anything like that might cover some of those damages, and they probably wouldn't the pain and suffering portion.
Yeah, we did have that.
You might was she able to get any kind of refund?
We don't know yet.
Okay. But the short answer is usually on these cruise lines, you disclaim any liability, and worse, if you're going to sue them, you usually have to go to their port of call. And sue them up there. So the short answer is, I'm not certain if you've released all liability or not. And are you saying this happened up in Alaska?
Yes.
You might have to go to Alaska in order to sue, which means you might have to get an Alaskan personal injury attorney.
Hello? Hello?
All right?
Yes, I'm here.
Yeah, so that's what I'm saying. You might have to use an Alaskan personal injury attorney.
Okay.
But I'm not sure if that disclaimer is going to be binding or not. My thumbnail is it probably is. Did she assume the risk? And, of course, whitewater rafting is an ultra-hazardous activity, and if they have you sign an assumption of the risk, you're probably out of court.
Okay. I mean, this was the easiest rapids, and I'm just saying, without the proper equipment, naturally her head banged pretty hard.
Right.
She didn't have a helmet on.
Understand, and that's the next question is, did she consent to that? And that's the interesting question. So,
okay.
Richard, I don't know the answer, but it's well worth looking into.
Thanks very much.
All right. 540-0580, Carl Rominger here answering your legal questions. And, of course, remember that if you're listening right now and you haven't had a chance to call in or you don't know when you're going to be able to call in and during the bonus hour, because we're going to be live on the air till 3 here, and then from 3 to 3:45 we'll be doing the bonus podcast. You can keep calling in. So feel free to keep calling in, 540-0580, and I'll keep taking your calls all the way up past 3:45. Bob, you're on WHP 580 with attorney Carl Rominger.
Yeah, this is a good one. Bob Durgan would love this one. Okay, we have a cabin over Mifflin County, and we pay the taxes every year, in the fall and the spring. Well, I get a notice that the school taxes were not paid, and they're starting to incur interest on us.
Right.
Now, I should be a better paperwork person than I am, but I don't. I can't find our receipts, but I know it was paid because we always pay it. So I called the supervisors up of the township, and he told me that the person they used to have doing the taxes retired. They got this new guy in, and he just screwed everything up. I mean, he wasn't ripping them off, but apparently somehow he didn't document everybody's taxes that they paid in.
Okay.
And he said even as a supervisor, he got a tax form. Like, now if they try and sell this, and eventually I do come up with the paperwork stating that we did pay the taxes, what kind of recourse do I have of, getting the cabin back?
So it was sold at a tax sale?
No, not yet. They say we owe taxes, and if we don't pay the taxes, they're going to sell the property.
I wouldn't let that happen. I would pay the taxes and then fight for the money back, basically pay it under reservation.
Okay.
Because if you're wrong, you ain't getting it back. If you're right, you'll be able to reclaim the excess money you paid them without a problem.
Okay.
And how much, kind of dollar-wise, how much are we talking about here?
It's almost $1,000. It's like $983 or something.
And the cabin's worth more than that?
Oh, God, yes.
Then I wouldn't fool around. I'd pay first and disgorge back later. An overpayment of taxes would be returned to you.
Okay.
Yeah. Yep.
Okay.
Because if it's sold at tax sale and there's a problem, maybe we can undo the tax sale, but that's going to cost you thousands and thousands of dollars.
Right.
So I don't know how many guys are in the cabin with you, but divide 1,000 or 900 by the number of guys, and
it's just my wife and I.
Gotcha.
I mean, I know we paid it, and the supervisor even admitted that this new tax guy has screwed up.
Right. But I just don't want you to find out that somehow he never even cashed your check or something.
Well, no,
You know what I mean?
Okay. Right, I understand.
I just don't want to take any. I would not counsel risking it because the asset value, and the answer is you'll be able to disgorge your money later. Okay. Got to let you go. 540-0580, Carl Rominger here answering your legal questions. You can keep calling from now until 3:45. So keep calling in from now until 3:45. I'm going to talk with Linda and Ed here holding. And don't forget to come back next week. And in the meantime, you need to get a hold of me. Go to weekendappointment.com. You can hire me for your legal problems. Got a personal injury, come see me.